Listen closely, because what I'm about to break down for you represents a turning point well referenced for decades to come. Less than half a day ago, while the country was asleep, 3 federal judges in our nation's capital handed down a decision. And that just rewrote the playbook on how much protection a former commander-in-chief actually gets. If this is your first time here, subscribe immediately, enable every notification. The events unfolding right now, over the coming 3 days, will be dissected in constitutional law courses 100 years from now. You don't want to be playing catch-up when everyone else already understands what happened. So here's what went down early this morning, around 6:45 Eastern. The D.C. Circuit didn't just reject Donald Trump's request for an emergency pause. They dismantled his entire approach to defending himself in court. And pay attention to the timing here. Trump's attorneys submitted that emergency filing close to midnight yesterday. The court came back in under 8 hours. No scheduling hearings, no requesting more paperwork. None of the procedural moves you see when judges are genuinely torn about a tough legal puzzle. Just a flat rejection per curiam, and that's the technical language means the whole bench. All 3 jurists, total consensus, 0 disagreement, absolute unity. Now listen to how they phrased it. Quote, former President Trump's alleged efforts to remain in power despite losing the 2020 election were unprecedented in our nation's history. I've spent years tracking courtroom language. Judges don't throw around unprecedented without serious consideration. That single word carries massive weight. It's telling you this isn't even close. This isn't some complex constitutional riddle requiring careful judicial gymnastics. This is about someone who allegedly refused to accept defeat and tried clinging to authority. And nothing about executive protection was ever intended to shield that kind of behavior. The ruling established 4 crucial points. Pay attention. First, absolute rejection of total immunity. Second, Trump's conduct falls under private actions, not official presidential duties. Third, the criminal accusations can move forward through appeals. Fourth, a legal standard that now impacts every other criminal matter. Trump is dealing with all of them. Here's why this is bigger than what you're hearing on cable networks. Consider every major presidential controversy in our history. Watergate, Iran-Contra, the Clinton impeachment. In each situation, the sitting president either stepped down before facing charges, got pardoned, or dealt with consequences that never reached an actual criminal trial. Nixon got a pardon from Ford before indictments could happen. Reagan's people took the heat for Iran-Contra. Clinton got impeached but never criminally prosecuted. What's unfolding right now has 0 historical parallel, none whatsoever. A former president is staring down criminal prosecution in 4 different court systems while his immunity arguments crumble simultaneously. This is constitutional ground the framers knew might someday be necessary, but prayed would never actually get tested. Well, we're testing it now. Trump's lawyers had a fallback option. They always do. The Supreme Court, 6 conservatives, 3 that Trump personally appointed. Chief Justice Roberts, who's historically worried about the court's public image, surely somebody up there would intervene, slow things down, preserve some institutional dignity around the presidency itself. Here's the reality. Complete silence, not from the liberal justices, from the conservatives, from Roberts, from Alito, from Thomas, from the very justices Trump elevated, Kavanaugh, Gorsuch, Barrett, nothing at all. No emergency action, no behind-the-scenes maneuvering, no signal that any justice thinks this needs immediate Supreme Court attention. Senator Lindsey Graham, Republican from South Carolina, one of Trump's most dependable supporters, actually said this publicly. If the Supreme Court doesn't step in, we might be looking at a criminally convicted nominee. Heading into 2024, a Republican senator talking about the Republican frontrunner. Just putting that out there for everyone to hear. If this breakdown is helping you see what's really happening, hit that like button. It pushes this analysis to people who need the unfiltered version, not the watered down narrative you're getting everywhere else. Now here's where the timeline gets brutal. Judge Tanya Chutkan, overseeing the federal election case in Washington, has invoked the Speedy Trial Act. That law mandates trial must start within 70 days once immunity questions are settled. The appeals timeline kicked off this morning, February 12th, that's when the full written decision from the D.C. Circuit is expected. 28 days out, after that, drops. Prosecutors can demand immediate trial scheduling. And Judge Chutkan's original date was March 4th. If the Supreme Court stays out of it, that date becomes locked in stone, immovable. And here's something about unanimous 3-judge rulings. The full circuit almost never reverses them on review. Plus, the Supreme Court already turned down one immunity petition from Trump in this same case. The window is narrowing. Escape routes are vanishing. Trump's legal team sees it happening. Let me explain what's going on inside Trump's defense operation at this moment. They've examined the witness roster. Mike Pence, his own vice president, Mark Meadows, his own chief of staff, Pat Cipollone, his own White House counsel, Cassidy Hutchinson, who witnessed everything firsthand. They've gone through the evidence prosecutors compiled, text exchanges, emails, call logs, the January 6th video the entire planet has already watched. They know what's coming at them. And the response, nonstop, Truth Social posts, all capital letters, claims of election interference, attacks on Judge Chutkan, accusations of corruption, warnings directed at his base. Then came the post that triggered alarms across every federal law enforcement office in Washington. Quote, "If these witch hunts don't stop, our country will face problems the likes of which we've never seen." Read that one more time. A former president facing prosecution for allegedly attempting to subvert an election is now suggesting civil disorder if the legal process continues. This goes beyond campaign talk. This is potentially intimidating witnesses. This is potentially obstructing justice. Every single post becomes evidence, gets captured, time-stamped, saved, and delivered to prosecutors who are constructing an obstruction case as we speak. He can't help himself, and every word strengthens their position. Washington, D.C. looks like it's bracing for conflict right now. Capitol Police elevated their readiness, security fencing going up around the federal courthouse, counter-demonstration groups mobilizing, multiple agencies coordinating law enforcement response. This is day one of a 70-day countdown. FBI threat evaluations have been raised, joint terrorism task forces tracking extremist online activity, U.S. Marshals getting ready for enhanced courtroom protection, covering prosecutors, witnesses. The January 6th taught them to take this man's word seriously. 3 years back, weeks of false election claims and fight rhetoric culminated in violent assault on the Capitol. The sequence is documented. Officials in Washington are losing sleep over this. So let me specify exactly what Trump is actually charged with, because this matters. These aren't vague disputes about executive authority. These aren't normal political arguments. These are for federal obstruction of an official proceeding, election legitimacy, peaceful power transitions, the fundamental operations of democratic government. That's what's being judged. And the jury pool, Washington, D.C., where Biden captured 92.1% of votes in 2020, prosecutors aren't depending on hostile witnesses or debatable evidence. They've got testimony from Trump's own vice president, his own chief of staff, his own White House counsel, people he selected, people he relied on, people who were present. But even if you think the DC prosecution has weak spots, even if you imagine some scenario where Trump avoids conviction there, Georgia's lined up next. Fulton County DA Fani Willis, RICO accusations, 19 co-defendants, meaning 19 potential cooperating witnesses, and the Georgia evidence stands independently separate from the federal case. There's the recorded call. You've heard it. I just want to find 11,780 votes. There's the fake elector operation with a complete paper trail showing forged documents sent to the National Archives. There's the voting system breach in Coffee County. Different evidence, different laws, different criminal exposure. And none of it relies on federal immunity arguments whatsoever. So Georgia is state level. Federal immunity principles don't touch it. If you're still with me, leave a comment. Do you think Trump gets convicted before Election Day or finds a way to push everything past November? I genuinely want your take on this. And Florida, we haven't even discussed Florida yet. And the classified materials case, the storage boxes at Mar-a-Lago, the items seized by the FBI, these are routine paperwork, disagreements. Nuclear information, military operational plans, and intelligence source identities. Under 18 U.S.C. 793, retaining classified defense information carries up to a decade in prison per violation. Trump faces 32 counts, and there's indication that surveillance video at Mar-a-Lago got erased after legal demands were issued. If prosecutors prove Trump ordered that deletion, that's obstruction of justice, serious federal felony, up to 20 years. This isn't theoretical, it's procedural, and it's accelerating. The Republican Party is splitting apart in real time. MAGA loyalists digging in deeper, establishment pragmatists heading for the exits, internal threats against anyone criticizing Trump, and Republican election officials who certified 2020 results still getting death threats today. But here's the math happening behind closed doors in every Republican campaign headquarters across America. Polling shows 32% of Republicans say they wouldn't back Trump if convicted. 32%. That number makes him unelectable nationally. Senate Republicans in battleground states like Montana, Ohio, Pennsylvania are already creating distance. They understand a convicted criminal at the top of the ticket sinks everyone downstream. And the 14th Amendment question remains unresolved. Section 3. The insurrection provision. It prohibits anyone who participated in insurrection from holding federal office. No criminal conviction necessary. Colorado already removed Trump from their primary ballot. Maine did the same. The Supreme Court will determine if those removals hold up. The mere fact these conversations are happening at the highest government levels and that constitutional experts are being consulted about insurrection disqualification tells you precisely how critical this moment has become. And here's what's occurring beyond our borders while we're consumed by this. NATO partners are worried. A former U.S. president threatening domestic chaos while facing criminal charges for trying to overturn an election. This is unprecedented in contemporary democratic societies. Our adversaries are observing, testing for vulnerabilities, China increasing Taiwan pressure, Russia consolidating Ukrainian territory, Iran accelerating uranium enrichment, statements warning of chaos if prosecutions proceed on campaign rhetoric. They're danger signals. Law enforcement is responding accordingly. FBI threat assessments elevated. Joint Terrorism Task Forces monitoring extremist communications, U.S. Marshals preparing amplified courtroom security, protection details for prosecutors, witnesses, judges activated. History taught these agencies to take Trump's language seriously. January 6 followed weeks of election fraud, lies, and calls to combat. The coming 28 days represent the most hazardous period. Trump recognizes conviction is becoming probable. Control is eroding. And when Trump feels trapped, he intensifies. That behavioral pattern is documented throughout his business history, his presidency, his post-presidency. Jack Smith's investigation doesn't end with the D.C. indictment. Evidence of witness tampering, obstruction of justice, conspiracy to obstruct has been forwarded to prosecutors in multiple grand juries operating concurrently, Washington, D.C., Miami. New York State charges could surface even as federal cases advance. Tax evasion, bank fraud, campaign finance violations, insurance fraud, each progressing independently, each generating distinct legal jeopardy, where in constitutional space the framers anticipated but desperately hoped would remain theoretical. Multiple accountability systems engaging simultaneously. Criminal prosecution, civil lawsuits, congressional examination, potential disqualification under the 14th Amendment, and observe what transpires within the Republican Party over these next 4 weeks. The divisions forming now are in temporary alliance friction. They're fundamental restructuring. Once elected Republicans publicly abandon Trump's support. The barrier doesn't reconstruct. It collapses. Every new defection facilitates the next. Every calculated silence communicates louder than any defensive statement. Additional unfavorable court decisions are arriving, more damaging witness revelations leaking to media, more former officials coming forward, more Republicans quietly hoping for conviction so they won't face the choice between loyalty and viability. Here's the question that genuinely matters. This has moved beyond whether Trump gets convicted. Given the evidence, the witnesses, the jury composition, conviction in at least one jurisdiction seems increasingly probable. The actual question is what form of American democracy emerges after we've tested every institutional safeguard, designed to hold presidents accountable. Donald Trump constructed his entire political identity on the premise that regulations don't constrain him and that he transcends consequences, that willpower and media control could override institutional boundaries. What's occurring now is the disintegration of that worldview, not through rhetoric, through procedure, court directives, jury assembly, sworn witness testimony. The criminal justice apparatus is methodical, systematic, inexorable, completely indifferent to Trump's fury. Legal process is the single domain has never controlled. The countdown is active. The evidentiary foundation is established. The next action belongs not to Trump's attorneys, but to the federal judicial system. And that system doesn't negotiate. The approaching 10 weeks will decide not merely Donald Trump's individual destiny, but whether accountability retains significance in American democracy. If you want to stay ahead of the sanitized corporate media story and grasp the actual legal architecture driving this case, subscribe to this channel immediately. We examine court filings. We interpret legal tactics. We monitor what prosecutors are genuinely constructing without the partisan interference. Subscribe now. Activate notifications, because the next 28 days will move faster than traditional news can comprehend. Drop your forecast in the comments. Convicted before the election, or does he manage to lay past November? I'll see you in the next analysis.